Hi guys, welcome back to my channel. So today in this video I would like to continue my previous video entitled Shipping Law Review United Kingdom, England and Wales. So this is the seventh part of the video. Classification. The following classification societies are recognized and approved by the UK government for the purpose of performing survey and inspections of UK registered vessels: ABS Europe Limited, Bureau Veritas Class NK, DNV, Lloyd's Register, Rhina UK Limited. Generally, classification societies exclude their liability in contract. Furthermore, according to the leading House of Lords decisions in Markridge and Co. v. Bishop Rockmerran, the Nicholas H. classification societies do not owe a duty of care to third parties in respect of their classification and certification duties. For environmental regulation are reshaping global shipping. 5. Collision, salvage and wrecks. Collision. Several international conventions relating to collisions claims operate in England and Wales. The conventions for the unification of certain rules of law with respect to the collision between vessels 1910 was implemented into English law by the Maritime Conventions Act 1911, repealed and replaced by the MSA 1995. The Collision Conventions 1910 set out the basic rules regarding civil liability for collision between vessels. Furthermore, the coal wrecks also apply to all foreign ships sailing in UK territorial waters and to all UK ships sailing anywhere in the world. They were also brought into force by the Merchant Shipping Distress Signal and Prevention Regulation 1996 and are updated from time to time by reference to IMO regulation. Salvage. The 1989 Salvage Conventions applies in England and Wales. There is no mandatory form of salvage agreement, but the Lloyd's open from LOF is by far the most commonly used. The LOF is governed by English law and provides the arbitration by the Lloyd's Salvage Arbitration Branch in London. The latest version is LOF 2020 and with the accompanying Lloyd's standard salvage and arbitration clauses. The contract is kept under review and updated from time to time in consultation with industry stakeholders and salvage practitioners, as well as Lloyd's when the LOF is not used. Parties to a salvage operation are free to agree their own terms and conditions for salvage, and in the absence of any contractual arrangement, the salvors may also bring a claim for common law salvage. Wreck removal. The MSA 1995 grant coastal authorities broad powers to intervene in relation to the handling of wrecks. These powers include the power to take possession of, removal, or destroy the wreck as required. The relevant authority is also permitted to contract with a third party for the removal or salvage of the wreck. The owner of the vessel remains liable for the cost of removing the wreck, and this liability is unlimited. However, this is usually a protection and indemnity risk. The Wreck Removal Conventions Act 2011 allowed the United Kingdom to ratify the Nairobi International Conventions on the Removal of Wreck, the Nairobi WRC 2007, adopted in 2007 and on 15 April 2015. The conventions came into force following ratification by Denmark on 14 April 2014. The Nairobi WRC 2007 imposes a number of obligations on ship owner, for instance, a requirement to obtain a certificate from a WRC state party, confirming the insurance or other financial security is in force in line with the Nairobi WRC 2007. 6. Passengers' rights. Passenger rights are dealt with by the mixture of common law, legislation, EU law, international conventions. In the first instance, the contract of carriage may apply to any dispute, subject to the protections of the Athens Conventions and EU regulation, such as the package travel, package holidays, and package tour regulations, 1992 as amended. The Athens Conventions was incorporated into English law in 1996 via Sections 183 of the MSA 1995. The conventions render a carrier liable for damage or loss suffered by a passenger in the event that the incident giving rise to the damage occurred during the carriage and was caused by the fault or neglect of the carrier. Under the Athens Conventions, as amended by the 1976 Protocol, carrier liability for death of or personal injury to a passenger is capped at 46,666 special driving right per carriage. However, under Article 7, England increased the limit in respect of its own national carriers to 300,000 Singapore dollars. The 2002 protocols to the Athens Conventions entered into force in England on 23 April 2014. This protocol increases the limit for carrier liability contained in the Athens Conventions to 215,000 Singapore dollars for each passenger injury or death. It also introduced changes to the liability regime for the loss of damage to the cabin and compulsory insurance of $250,000 per passenger. Although the Athens Conventions usually applies to the international carriage under the carriage of passengers and their luggage by sea, domestic carriage order SI English law extend the convention's protection to domestic voyages for which the point of arrival and departure are within the United Kingdom. The package travel regulation apply to package in which two elements of travel, accommodation, and other services are sold together. Therefore, this covers cruise and potentially overnight ferries. This regulation set out a consumer protection regime, which includes details of the information to be provided to passengers and that tour operator is responsible to the passenger for performance of the package. 7. Seafarers' right. The Maritime Labour Conventions 2006 MLC entered into force in England and Wales on 14 August 2014. The United Kingdom having been this 41st International Labour Organization or ILO member state to ratify the MLC on 14 August 2013. The MLC replaces various existing conventions and provides a new framework aimed at protecting seafarers' rights. The MLC was established by the ILO in 2006 and it aims to provide a comprehensive set of rights and protections for all seafarers. The MLC applies to all commercial vessels with the exceptions of ships navigating inland or sheltered waters subject to port regulation, fishing vessels, warship and naval auxiliaries, and traditional ships such as those. The MLC sets out minimum standards for seafarers working on ship, including the minimum age, medical certification, training and qualification, hours of work and rest, welfare and social security protection. Seafarers who earn substantial employ in the United Kingdom may also benefit from the protection of English employment law, although many protective regulations contain exemptions for offshore work. Vessel owners and employers must also extend the protections to seafarers regarding safety at work and, for example, providing suitable equipment. So this is the end of the article. Don't forget to watch my previous part, and also don't forget to like, comment, and subscribe. Bye.